Ms. Drogin, you may begin, and you have 5 minutes.
Chairman, Ranking Member, and members of the committee, thank you for the opportunity to testify on the adverse effects of Plyler v. Doe and how subsequent federal policy, particularly the Obama administration's Dear Colleague letter, has created a contradiction harming students, schools, and communities. Plyler v. Doe held that states cannot deny illegal immigrant children access to public education. Texas has fulfilled that obligation. Our Constitution requires a free public education system, and Texas has built one of the nation's most robust accountability systems in the nation. Our A through F accountability system evaluates schools based on standardized test performance, graduation rates, and college readiness indicators. These ratings have real consequences. They can trigger state interventions, leadership changes, campus restructuring, and school closures. In recent years, roughly 16.6% of Texas districts have received a D or F rating. The ratings drive major policy decisions like student funding, and it relies on accurate demographic data. Yet federal policy prevents states from collecting one key category, the illegal immigration status of K-12 students. FWD.US estimates that approximately 111,000 students in Texas are illegal immigrant children. This restriction does not come directly from Plyler v. Doe. Instead, it stems largely from a 2011 Dear Colleague letter issued by the Departments of Justice and Education, which warned that asking about immigration status could discourage enrollment and create a chilling effect. The Dear Colleague letter is agency guidance. It's not law passed by Congress, and it is not required in Plyler or by the Supreme Court. Congress should clarify that it cannot prevent states from collecting necessary data to educate students. Every effective education policy relies on demographic data. Schools identify student populations to provide targeted support, whether it's for low-income students, English learners, or students with special disabilities. And they track things like race, gender, attendance, discipline, and even parental incarceration. This data is used to identify needs and measure outcomes. It is not used to stigmatize students. It's universally accepted that schools must have it to identify student needs, measure outcomes for the students, the schools, and the entire education system. Yet, illegal immigration status is the one characteristic schools are effectively barred from measuring. States are asked to address complex challenges while remaining blind to a key factor influencing outcomes. This contradiction undermines the very logic of Plyler itself. If illegal immigrant children face serious disadvantage, as the court has recognized, schools must be able to identify them in order to provide appropriate supports. Evidence suggests illegal immigrant students face challenges way beyond language barriers, including higher absenteeism, mobility, interrupted schooling, and greater educational needs. A study in social science and medicine found that 97.4% of Central American and Mexican migrant children experienced at least one traumatic event before entry, and 44% showed psychological or behavioral concerns. Texas medical experts report many require significant mental health support due to sexual and violent trauma experienced during migration. These realities affect accountability systems and other students as well. Schools must determine whether performance challenges stem from language barriers, trauma, or interrupted education, but policymakers cannot answer these questions or on how illegal immigrant students perform as compared to other groups. We see the consequences all across Texas. Campuses receiving failing ratings for 5 consecutive years face closure, restructuring, and state takeover. Recently, districts such as Fort Worth, Beaumont, Connolly, and Lake Worth ISD have faced such risks after 6 campuses repeatedly received failing grades. These campuses share strikingly similar characteristics. Between 80 and 97% of the students come from low-income households, compared to 60% statewide. At 5 of the campuses, 64 to 92% of students are considered at risk of dropping out. A Stanford education researcher, Beth Schuler, explained, quote, "I don't think we want to lose sight of the fact that demographic composition of a school system is the thing that's going to be most predictive of variation and performance and outcomes," end quote. When schools struggle or close, communities are disrupted, enrollment declines, families move, and local economies suffer. In short, the downstream effects of Plyler v. Doe affect every single student in the state of Texas, in the schools and in the community. It's not just the illegal immigrant students. Congress should require the Department of Education and Justice to issue new guidance clarifying the 2011 Dear Colleague letter can't prevent states from collecting data on illegal immigration or legal immigration status of students. Congress should also pass legislation allowing states to collect immigration status, both legal and illegal. If states are required to educate illegal immigrant students, they must be allowed to identify the student population status to fully understand and address the adverse effects of Plyler v. Doe. Thank you, and I look forward to your questions.
Thank you, Ms. Drogin.